Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. The papers, the news channels, particularly the English news channels, are abuzz with Bilkis Banu case. 11 accused came out of Godhra jail who were previously convicted for life in Bilkis Banu case. How they came out, let us discuss in a legal way. Friends, at the outset, I want to inform you that this has got political ramifications, political overtones, but I am not concerned with that. I am concerned only with the legal provisions because they may target the Honorable Court also in future. Because I heard the committee, the EET, that is Entertainment Channel, in which this case has been discussed at length. Right. To be precise, before proceeding with the case, let us know brief facts. You all know the Godhra incident, the setting on fire of certain bogies of Sabarmati Express in the year 2002. It has become a sensational issue internationally. No doubt, the Karsevaks, they have been burnt alive. So maybe as a countermeasure, because some other community people are involved, these people, they want to take vengeance. Now, as far as our case is concerned, on 3/3/2002, this Bilkis Banu, she was gang raped by 20 or 30 people, gang rape. And 7 members of her family were killed, and extended family total came to 15 persons, they were killed. In retaliation to the Sabarmati Express or the Godhra killings which occurred on 27th February 2002, where 59 Karsevaks were killed. Right? Actually, knowing the incident, Bilkis Banu fled away to her village with her 3-year child, and that child was also murdered. It has become a sensational issue. Ultimately, the CBI, they have to take up investigation, and during the trial also, lot of pressure came on Bilkis Banu, and the trial was transferred from the Gujarat court to state of Maharashtra court, Maharashtra High Court. Ultimately, I think on 21st January 2008, 11 accused were convicted to life imprisonment. So, for gang rape and murder, right? And actually, Bombay High Court also upheld the same, right? Now they are in jail for the past 15 years. So this is the background story. Now, one of the convicts by name Radheshyam Shah, he has approached the Honorable Supreme Court, and he filed a petition before the Supreme Court for remission of their sentence, since already 15 years have been completed, even though the life sentence, of course, previously it was for 14 years as per section 31 CRPC. Of course, now with the landmark case of State of Rajasthan versus Zamil 2014. So it is till the end of the biological life. Whatever it is, since they have completed 15 years of sentence in the jail, they wanted remission. They filed a petition. So the Honorable Supreme Court asked the state of Gujarat to take a decision in this particular matter. Right? This happened in the year April 2009. In April 2009, Supreme Court directed to the state here, 2009, Supreme Court asked the state to give compensation of 50 lakhs to this Bilkis Banu, then a house and a job, things like that. Right. Now, since we are discussing this, Radheshyam Shah, he approached the Gujarat High Court seeking the remission under section 432 CRPC. And actually, Gujarat government raised objections stating that the appropriate government is state of Maharashtra because the judgment came in the state of Maharashtra. But of course, when the matter came to the Supreme Court clearly stated that the state of Gujarat, where the incident has taken place, they have got the power under section 432 CRPC. This was decided by the Supreme Court on 13/5/2022. Right. Now, in this connection, so as per another important point is there. Actually, so first of all, let us know what is 432 CRPC. You all know 432 is remission, 433 is commutation. So, whenever the government power to suspend or remit the sentence, whenever an application is made to the appropriate government for the suspension or remission of a sentence, the appropriate government, please remember, may require the presiding judge of the court where the conviction has been confirmed to state his opinion whether the application can be granted or not. Suppose if the government wants to release them to suspend their sentence, yes, they can do it, but only with the permission of the court. So the state of Gujarat, they have appointed a committee under the district collector, and the committee agreed to release these people on because they have already completed 15 years of jail life. So on 15th of August 2022, they walked free out of Godhra jail as per the decision. Here there is a twisting point. Actually, there is a provision, there is a policy in 1992 by the state of Gujarat that they can suspend, they can so-called remit the sentence of anybody. May him be involved in a rape case, may it be a murder case, yes, they can. Under Article 72, you know, the President of India is empowered to give pardon. But in 2014, the policy was changed. In 2014, the policy was changed stating that the persons involved in murder or rape cases, so they cannot be given any remission. Now, the tricky issue is the incident took place in 2002. The judgment was in 2008. At that time, the policy of 1992 was only in existence. 2014, the new policy came. Now, which policy they have to adopt? Once again, the court reiterated basing on the principle of ex post facto laws. You know what is ex post facto law? Already I told you. Suppose if in 1978 the punishment for theft is 3 years, even though this man is convicted in 2022, the punishment should be given of only 3 years. Suppose if it is enhanced to 5 years, even then you cannot give. So likewise, 1992 policy, since it was existence till 2008 or till 2014, then definitely the old policy can be followed. So according to the old policy, yes, the persons involved in rape or murder cases can be given the so-called remission or suspension of sentence. That's why they are lucky. Now, just before concluding, I want to tell you this has political overtones. Why? Because the victim Bilkis Bano was 100% supported by Teesta Setalwat and a police officer by name Ram Kumar. I forgot his name. So both of them are now in jail, whereas the accused persons, they are out on bail. Now Bilkis Bano, she cannot go to her native village because all of them belong to their particular village. So now she is in an embarrassing position. So whatever it is, law is law, we can't help. So as per law, we have discussed so many points here. 432 deals with remission or suspension of sentence. 433, commutation of sentence. Then ex post facto laws and transfer of the court case from one high court to the other court by the Honorable Supreme Court of India. So appropriate government also we discussed. So all these things come under this judgment. Of course, a lengthy judgment and actually a controversial judgment also, but still to make you aware. Because in the morning walk, some of my friends asked me, what is this Bilkis Bano, sir? Previously, when we studied law, it was a Shah Bano case, Shah Bano versus that Hassan advocate case that is relating to maintenance of Muslim women. Then I think 2018 or so, this Muslim Saira Bano triple talaq case and a judgment and a new act has also come. What is this Bilkis Bano case? Of course, most of the people, they are not aware of the particular case. Only people, educated people, they know. But normal, even advocates, some of the advocates, I'm sure they do not know. Whatever it is, we have, by reading the judgment, they can easily understand. But to make it clear, I am making this video in simple terms, right? Thank you very much.